how about could you offer any advice on a potential seller who doesn't understand legalese and is very paranoid about being burnt by the contract? Like, oh, if it doesn't sell, I still owe you a commission, those types of concerns.
Well, yeah, so in the representation agreement you're talking about?
Correct.
Yeah, the representation agreement has a lot of language in it to protect the brokers from business owners that in the past have done side deals or backdoor deals around the broker. And so some of the language in there, every time a broker gets burned, essentially the language gets changed to try and create some protection in there so it can't happen again, or so that it won't happen again. And ultimately things do happen. But I think usually what I tell a seller, a prospective seller, is, look, we need to, selling a business is a partnership between the broker and the seller. Broker can't sell the business by himself. The seller might be able to. It's typically not the best, but they might be able to. But at the end of the day, you have to work together. If the seller has no intention of doing any type of side deal or backdoor deal, then he shouldn't be concerned with any of that language, because every purchase agreement has contingencies where, a buyer has the ability to essentially walk away from the deal and not close. If the due diligence doesn't match up, if they find, material differences between what's been represented in the numbers versus the reality, right? So as long as a seller is providing you with accurate tax returns, like copies of the ones that were actually filed, not a second set somewhere, as long as they're providing you with the proper documentation and are not intending to do some type of a backdoor deal, they really shouldn't be that concerned. So that's really what it comes down to. But I would address their concern, just ask them to point out what sections of the contract that they're concerned with, and then go over it with them and just say, okay, well, basically what this says is, if I'm out there working, like for example, canceling the contract before it expires or before it terminates. So if I'm out there selling your business or marketing your business for 6 or 8 months, and then you all of a sudden decide that you don't want to sell anymore, maybe you land a big contract or something like that, I need to be able to be compensated for my time and all of the work that I put into the deal. I mean, that's fair, right? And so they may say, well, yeah, but I don't want to pay the full fee, but I'm willing to pay a termination fee. Like, well, maybe we can put something together. So you just have to go through whatever their issues are and explain it from your side. It's like, if they're ultimately, the rep agreement has to protect you as a broker, because you're putting in time, energy, effort with no guarantee of compensation unless you sell the business. So anything that the seller does that sabotages your efforts, you need to be able to be compensated for it. Does that make sense?
Yeah, that does. And I think this person is just looking at it from the angle of, he's paranoid that I'm going to screw him. So he's trying to figure out how I'm going to use this contract to screw him.
Mm-hmm. Well, I mean, and the other thing too is that if they point out certain paragraphs that they're uncomfortable with, then you can explain the purpose of it and just say, how would you like to address it? I mean, because I'm happy to discuss making some changes, but how how are we going to make sure that this is covered? And a lot of times they don't know. So, and most of the time they don't want to hire an attorney, depending on the size of the deal. If it's a small deal, a lot of times they don't want to hire an attorney to go through the rep agreement and, you know, figure out. And if they do, I mean, I've had attorneys that, you know, or clients that have gone through and they have had an attorney go through the rep agreement and they've tried to eliminate a lot of the broker protections. And at that point, you know, I mean, I explain it to the sellers, and if they insist on having their attorneys, you know, strike out all the protective language, like the 2-year tail. There's a 2-year tail at the end of the, well, when the agreement, the purchase or the rep agreement terminates, if any, you know, if you've introduced the business to a buyer who buys it within 2 years, you're still due your fee. That's pretty standard in business brokerage, because otherwise what happens is buyer and seller have their conversations, sometimes in English, but oftentimes in other languages that you don't understand, and agree that they're going to wait until the expiration date and then do the deal without you the next day or the next week or the next month. So obviously that's not fair to the broker. And so that's why there's a 2-year tail in there. So if they, you know, if an attorney wants to strike that, say no, you know, after the contract terminates and after that you get nothing, and it's like, well, I'm not willing to spend my time, energy, and effort on a project where somebody can wait until the day after the expiration and completely exclude me, even though I've done all the work, I've brought the buyer to them, and I've gone through the process. You know, if they can make it so that I can't be compensated for my work, then why should I invest my time, energy, and effort into that project? So you just be very straightforward with the sellers, lay the cards out on the table. This is what this is for. This is how it protects me from sellers that, you know, you and most sellers are fine and nice and, you know, ethical and all that, but there are a subset out there that are not. And therefore we have to have certain language in the rep agreements to protect us. So.
Thank you.
Mm-hmm.